With my lord's kind permission, my lords, the court's mic is on mute. My lords. List 1, serial number 16, my lords. I request that I be given 2 weeks' time, my lords.
Page-wise adjournment. Page number 3, serial number 10 and 11. Page number 4, 12 to 13. Page number 5, 14 to 19.
Serial number 15, my lord. I am for the petition, my lord.
Serial number?
15. I am for the petition. Pray for days time, my lord.
It's a 2019 matter.
Senior is not keeping well, my lord.
We'll see when the matter reaches, why is it pending and whether to be adjourned or not. Yes.
Page number 6.
Serial number 16, my lords. Serial number 16, previous. Because I am for the petitioner. I'm unwell. If it could be taken up next week, my lords, or
have you informed the other side?
The other side is in court, my lords. Mr. Ravi Shankar is in court.
I appear for the responsible.
Yes, what do you say?
Lord, see what has happened. An original application before DRG has already been allowed. Already this writ petition itself has become infractious.
We'll take it up on Monday.
By please, Your Lord.
Tell us this matter on Monday.
Obliged. Obliged.
Yes.
Page number 6, serial number 20 to 26. Page number 7.
24. Yes.
Both parties. The petitioner is partially taken care of by the mother. The mother has fallen ill. Therefore, she was unable to come to office and inform the other side. Even they have not filed the attendance. My request for 10 days.
This is matter after 4 weeks. At the request of non-counsel for the petitioner, it is submitted. The same is informed to the counsel for the respondent. Yes.
Page number 7, 27 to 30. Page 1 for dismissal matter, serial number 1, Girisha Arjay.
Lord, I appear for the petitioner.
Yes.
Lord, previously I have argued this matter, and on the last occasion, I am sorry, my lord, I couldn't.
It's okay. Now
appear.
you can argue.
The matter is, my lord, the petitioner had sought a maintenance from the husband, that is respondent, in criminal miss 530 of 2013. The order dated 15th December 21 in criminal miss 530 of 20 is at page 12, Your Honor. My lord, your lordship may kindly see the learned judge has not looked into.
Petition filed is dismissed. Where are the findings? Please come to the findings.
My lord, the finding is issue number 1, my lord. She says that whether petitioner proves that respondent has neglected or refused to maintain her. That is issue number.
Please come to paragraph number 28.
28, my lord. In this case, petitioner and respondent have filed affidavit in compliance of Supreme Court guidelines asset. Petitioner has stated that her general monthly expenses is 20,000. It is stated that her qualification is graduation. Presently, she is taking tuition at the home, getting income of rupees 6 to 10,000 per month. Further, it is stated that respondent has studied, respondent, that is husband, MSc DFD and is proprietor of emergency pest control. He is earning more than rupees 3 lakhs per annum. Apart from the above, it is stated that respondent owns luxurious house in Mysore and also having a commercial BDA site in Bengaluru. But in spite of all this, my lord, no maintenance is awarded.
Let's read. Let's complete reading that.
But the petitioner has not produced any documents while adducing evidence or along with assets and liabilities show that respondent is having income of 3 lakhs per annum and is the owner of pest control services. But quite interestingly, my lord, the page 45 may kindly be perused, my lord. This is a erroneous finding, my lord. Page 45. There is no wedding in existence at all. Though respondent admits that I am the legally wedded wife, the learned judge records that the wedding is not at all in existence. Refused to at least direct him to pay 10,000 rupees. though there is already a divorce is be granted. And merely because she asked for permanent alimony during the MC proceeding, my lord, that has been taken note of as a greedy attitude of the lady. Therefore, she is not entitled to maintenance. That is the finding, my lord, recorded by the judge.
It is admitted that a sum of rupees 21 lakhs 65,000.
That is false, my lord. That's a accounts jugglery made by the respondent. At the time of marriage, her parents' property was sold. They were paid 5 lakhs, and that 5 lakhs amount has been bifurcated into 2 deposits in favor of the petitioner and respondent. That amount has been taken away by the husband, and he invested in some site and other things in Bangalore. Then he withdrew it through petitioner, and again the amount is spent by him, and it is shown as 21 lakhs she has received. That is accounts jugglery committed by the husband.
When was the divorce? When was the divorce?
Divorce 3 years is over, Your Honor.
No, when is that?
2023, my lord. No alimony, permanent alimony is granted, even in divorce proceedings.
When they are still living separately?
2004, my lord.
Hmm.
2004, they were living.
2004,
Yes.
why will he transfer an amount in 2006?
But that is why, my lord, though they were living separately, the amount which was in the name of the petitioner deposited out of sale proceeds of her mother's property, he returned it as a statement.
MC petition was allowed on 34/2014, not 23.
Appeal dismissed, came to be dismissed.
So
High Court.
it was allowed on 34/2014.
Yes, my lord. 2014 only, the finding of the trial court was that she was greedy since because she demanded permanent alimony.
Let's not go into the findings of the court. You have to establish, at least before this court,
Yes.
what is husband's income, what is your income, and what are findings on other aspects of transfer of money or wrong.
My lord, I have produced the statement of account before the trial court, my lord. My lord, this is for a period
What was
between.
it? The divorce petition is filed on the ground of?
On the ground of cruelty, that is filed by husband, not by me.
That I understand.
And there was another allegation that she had not attained puberty and she did not comply the matrimonial obligation. That was the ground. The trial court dismissed the plea of the husband on the ground of nullity of marriage due to medical deficiency as falsely alleged by him without examining doctor. But however, the court said that since because she is demanding 5 lakhs permanent alimony, it amounts to cruelty, mental cruelty of the husband. And believing the accounts jugglery made by the husband, the court proceeded to say that 21 lakhs has been transferred from the account. I have, as exhibit P11, I have produced 2004 sale deed of the property belonging to the petitioner's family, my lord, where they executed a sale deed. that amount was paid. Even her sister's contribution was paid to the respondent.
No, with regard to this 20 lakhs that is withdrawn by you, what as observed by the court, where is your, you must have stated so in his objections. What is your response to that and what is the evidence?
Evidence.
Monday, please get with all that. Delete from the caption dismissal, list this matter on Monday. Yes,
Number
two.
2. Yes, we will.
My lord, this matter is being settled on filing a memo.
Take
My
that.
lord, information
Waiting for respondent number 1 in this matter, my lords. Matter in the state commission is different from this matter, my lords. The petitioner has asked for the quashing of proclamation of sale deed and has prayed for to direct a private respondent to register the sale deed, my lords, in their name. But the same prayer is being asked in the state commission and it is allowed in their favor, my lords. It is being taken care of in the state commission.
No, the petitioner says that is whatever the relief he sought is already, that is worked out. So what is your difficulty?
Nothing, my lords.
There are confirm.
I will record what he said in this.
Please,
My lord, there is a,
No, he doesn't want to pursue the matter.
please, my lords.
Yes,
my lord, the respondent have given the letter of confirmation also.
that's what, whatever you say in this, I will record.
Yes, yes.
The writ petition is filed, seeking the following prayer. A memo is filed before this court stating that as per the order dated 9/6/2025 and as per the State Consumer Dispute Resolution Commission order NEA number 44 of 2021, the respondent number 1 have agreed to register the scheduled residential property in the name of the petitioner. And as per the respondent, as per the respondent, the petitioner has paid the property tax up to date. Hence, in the light of the same, in the light of the said fact, the petitioner it is submitted that nothing remains to be adjudicated in this writ petition. Accordingly, the writ petition has become infructuous. Dismissed. Yes, next.
3.
Matured.
Yoganand Raju.
The present writ petition is filed seeking a direction not to dismiss as the petitioner from the scheduled property as per the Persian notice dated 10/6/2025. This writ petition is filed on 28/2025. On 1/9/2025, before a coordinate bench, there was no representation on behalf of the petitioner. Then on 30/10/2025, when this matter has come up before this court, even on that day, there was no representation. Hence, the matter is directed to be listed on the caption dismissal. Today also, there is no representation. Accordingly, the writ petition is dismissed as dismissed for non-prosecution.
Serial number 4.
Lord, serial number 4, my lord, I am appealing for the petitioner, my lord. Lord, already, my lord, I have served the.
Ask them to come and.
Appealing for one month.
Yes, next.
Lord, already, my lord, I have served the copy of the writ petition along with to the counsel of the Cavatar. The office objection may kindly be overruled, my lord. My lord, the petitioner, my lord, the challenging the, my lord, I kindly see, my lord, Annexure C. Annexure C, my lord, the issued by the bank for sale certificate on 10/8/2023, my lord. And page number 33. This sale certificate, my lord.
To set aside the order dated passed in SA number, why should we entertain this?
Yes, my lord. This
Why should we
Annexure C, my
entertain
lord.
this?
Yes, 1 second. Lord, Annexure C, my lord, I have challenged before the DRAT by filing SA, my lord. At the time of filing of essay, there is a delay of 92 days, my lord. The tribunal, my lord, at the time of hearing, my lord, has granted the interim order. Subsequently, after filing of the statement of objection, my lord, that application was rejected, my lord. Kindly see, my lord, the order portion, page number 60. My lord, on 6/5/2025, my lord, both the counsel as present, the essay is filed along with the IA number along with condonation of delay
No,
96.
I'm asking, why should you come before this court? Why not before DRAT?
My submission, my lord, I make one submission, my lord. Whatever the proceedings initiated by the bank, my lord, is without any authority because, my lord, already, my lord, the DRT has set aside the sale notice and sale deed, my lord. Kindly see page number 32, my lord.
No, I'll go to that. What I'm asking is, whatever is the illegality, why not DRAT? Why should this court entertain the writ petition?
My lord, the DRT,
Let us make it, let there be a uniform procedure for proceeding with the matters. You tell that this is an exceptional case or which warrants interference of this court under 226, but it can't be decided by the DRAT. If you convince the court on that point, I'll hear it. If not, you have to go before the DRAT.
liberty may be given, I will approach.
The
My
present
lord,
petition is filed.
one submission, my lord. This honorable court has already passed an order in the question of condonation of delay. In another matter, this is passed by Justice Krishna Dikshit.
I have seen that I have also reserved on matter because there are contra judgments of the Supreme Court which were argued.
Yes,
The present writ petition is filed. Seeking the following prayer. Learned counsel has argued about how the order passed in essay number 2 of 2024 is bad. When an order is passed by the DRT, necessarily the petition has to go before the DRAT. And if the petitioner wants to come before the court, and he has to convince the court that this petition can only be heard by this court by exercising the jurisdiction under 226, and the same cannot be decided by the DRAT. And as no such submissions are made before the court, when the petitioner has an effective alternative remedy, he has to approach the same, but he cannot come before this court. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to approach the DRAT in accordance with law.
Cell number 5, Dilraj Judai Rohit Saxena.
For respondent. In previous date also they have not.
I know.
On 13/2 they have.
The present writ petition is filed. Is filed questioning the notice issued under section 13(2) of the SARFAESI Act. The writ petition is filed on 13/10/2025. On 31/2026, then the matter was listed before this court. There was no representation on behalf of the petitioner. Hence, the matter was directed to be listed today on the caption dismissal. Today also, there is no representation. The petitioner is questioning a notice that is issued under section 13(2) of the SARFAESI Act. When a notice is issued under section 13(2) of the SARFAESI Act, the remedy that is available to the petitioner is to give a reply again to the same. Without giving a reply to the notice, he cannot come before the court. That apart, if the petitioner has an effective alternative remedy, the petition has to avail the appropriate remedies if at all he is agreed before the DRT. Even on that count also, there is nothing, this court cannot pass any order. Having filed the writ petition on 30/10/2025, even till today, the petition is not pursued the matter. In spite of the fact that the matter is posted for dismissal, giving an opportunity to the petitioner to appear in the RP of the matter, the writ petition is dismissed for non-prosecution. Yes, next. They can do it. Yes.
Cell number 6, V. Rajaya.
Reduce the Tibet. Yes. Don't say it. Yes. नहीं, बाद में देखेंगे. Yes. The writ petition is filed, seeing the following prayer, same like in other matter. Right from 17/11/2024, the matter is being listed before the court. When the matter came upon same 31/1, no representation, accordingly dismissed for non-prosecution. Yes.
Serial number 7.
I appear for respondent, my lord.
Yes.
In this case, I have also filed my objection statement with them. They have filed, thereafter now they have filed SA 72 of 2006 at DRT2.
They're not coming to the court.
Yes.
What is assigned in this?
Yes, they have made a representation informing that they will pay
They
the
produce within time on issue directing response. What is the representation?
2 lakhs per month. Their installment they want to pay, but they are due 60 lakhs rupees. So the one-time settlement, we have the bank has informed. The bank has informed, replied to that letter. To consider their representation, first they should pay 25% of the amount due. They have not paid it.
So you have already addressed his representation dated 2/9/2020.
Yes, yes, I have produced it annexure R1
R1.
in my along with my objection statement.
Yes.
My lord.
The present writ petition is filed, seeing the following prayer. As there is no representation on 31/1 so and so, the matter is directed to be listed and the caption for dismissal today. Today also there is no representation. Then counsel appearing for the respondent bank has filed his objections, and it is submitted that pursuant to the representation dated 2/9/2025, they have addressed a letter to they have responded to the same by letter dated 18/9/2025, informing the petitioner that the total contractual liability as on 31/8/2025 is rupees 59 lakhs 4,635.13. Only upon receipt of the said amount, the bank will be in a position to examine and consider the request for further course of action. It is submitted that thereafter he filed an essay.
Yes.
Questioning what?
Now, to the SARFAESI proceedings, what we have
It
initiated.
is submitted that the SARFAESI proceedings were initiated by the bank that were questioned by the petitioner herein before the DRT.
They have prepared SA 72 of 2026.
72 of?
Yes, madam.
72 of?
2026.
By filing essay number 72 of 2026, Land Council 2026. Next para. Having heard the Land Council for the respondent, person material non-record, the only relief that is sought in this petition is to consider the representation in the light of the letter dated 8/9/2025. The petitioners the respondents have already considered the petition, hence nothing survives for consideration. Accordingly, dismissed as instructions.
Yes.
Number 8. H.V. Bhanu Prakash, for petitioner.
Respondent bank, my lord. My lord, the petitioner already approached DRT and obtained stay, my lord.
What is the number?
Essay number 11 of 2026.
11 of 20?
26.
26. The writ petition is filed, seeking the following relief. On 31/1/2026, as there is no representation, the matter was directed to be listed today under the caption for dismissal. Today also there is no representation. Land Council appearing for the respondent bank submits that the petitioner questioning the proceedings that are initiated under the surface.
I am for petitioner.
Yes.
The DRT is already granted a interim stay and the notice kindly dispose the above.
Then why is it not supposed to bring to the notice of the court, having questioned it before by filing a writ petition?
The notice has been issued during the course of the vacation. 3 days vacation is, that's why you filed a writ petition. That is.
When did you approach the DRT?
Yet after filing the writ petition.
30/12/20.
Then you should file a petition to withdraw it.
Isn't it? Yes.
Not today. When the matter came up on the last occasion, you don't appear. And this is you should have withdrawn the writ petition and filed the essay. That's a procedure. it is then counsel appearing for the petitioner submits that after filing this writ petition, they have questioned the very same order before the DRT, and an interim order was granted on 11/1/2026, and hence nothing remains for adjudication in this writ petition. Accordingly, dismissed as infractions. Yes, next.
Time for orders matter. Syed Akbar Pasha. HR Anita.
Lordship, recollect, Lord, this order, Lord, this writ petition is filed by the husband, Lord, seeking modification of order, Lord, the visitation right is been given to the husband, Lord, in the Mysore, where, Lord, the petitioner works in, Lord, the Chennagiri of Davangere district. The wife works in a Chikmagalur district. So Lordship has directed, Lord, in between place, Lord, Hosdurga, directed, Lord. Since, Lord, the first date of hearing, Lord, the respondent did not went there. Lord, when the previous date of hearing, Lordship again directed to, Lord, to make sure that a smooth visitation should be done in, Lord, in Hosdurga. Lord, both went, Lord, one meeting peaceful is done. The second, Lord, there was a holiday didn't went. Lord, so that order may be confirmed, Lord, one submission.
No, that is not correct, my lord. Second visitation, my lord, 29/12/2025, my lord. There is a clear order. If it is fourth Saturday, if it is a holiday, next working day, my lords. It means 29/12/2025, he had not attended, my lord. Then 24/1/2026 also he has not attended, my lords. 22/1/2025 only.
So what is to be done now?
I filed the recalling modification of the order, my lord, saying that, my lord, she has to change 4 buses, my lord, from the Chikmagalur to Hosdurga, my lord. And but there is a difficulty for that reason.
Because you didn't want it to be at that place.
Please, my lord.
Where are you staying?
I stay in, Lord, I work in a Chennagiri. I stay in Chennagiri. She's working in a Chikmagalur. She is staying in Chikmagalur. The baby is also staying with her, Lord, with the Chikmagalur. I have no objection, Lord, to appear before, Lord, District Legal Service Authority in the Chikmagalur itself. But they are denying it, Lord. They doesn't want it.
But either you don't want, he has no objection to come to Chikmagalur. And now, because you have an objection, some other place is given. Now you say that she has to change. By who is asking her to change 4 buses? Let him
It's a
come to
direct bus,
Chikmagalur.
Lord.
Because, my lords, in the Chikmagalur, there is a threat, my lord. For that reason, we denied. Otherwise, we do.
No, in Chikmagalur, where you stay, there is a threat to you. What is that? He is coming
Because
to Chikmagalur to where
he has
the place.
created nonsense, my lord. Earlier, he was created nonsense and he teared her reputation, my lord. For that reason, she is scared, my lords.
So what is to be done now? You tell the court.
Hassan.
Where is Hassan?
Lord, Hassan is again the same distance. For her, it is 100 kilometers. For me, it is a 250 kilometers.
Not 250.
250 kilometers. Lordship, Google it.
250, not 250.
Not a conducive to the baby, either, Lord, to the petitioner or the respondent. It is just a, Lord, mechanism adopted by them to harass me.
No, if it is before the Legal Services Authority, there is some watch, what is happening? How can you say that there is threat to you?
Because, my lord, she has created, there are many complaints were filed, my lord, earlier, and she didn't get any support from the police, my lord, because his auntie also an constable, my lord. She is not getting any support from the police also, my lords. He has blocked everything.
Lord, I am a Gaurav, please.
When he is exercising the visitation in the court to premises with the Legal Services Authorities, what will happen? Nothing will happen. I'll pose this matter on Monday, get instructions from your client.
Please.
So that in what is that, Chikmagalur?
Please, Lord.
Police protection.
But she is present before the court, Lord.
Police protection may be given.
Why?
Because she has threat.
Police are not there in the court premises. What protection you require? There is no this mediation center there in Chikmagalur.
Yes, Lord, it is a district headquarters. There is a
In the
mediation center.
Yes.
In the presence of so and so, that can be done.
Yes.
I'll ask.
She is present before the court, Lord.
On Monday.
Please.
Yes.
Serial number 10, Tejasvi KV for petitioner. AM Venkatesh.
This is a review petition, my lord. There is some confusion in the order. My lord, I was being placed ex parte before this honorable court. I am an illiterate person, my lord. The paper publication was taken, my lord. I could not able to see.
You have come today.
Now I am before your lordship, my lord. It can be disposed of on merits.
My lord, I am not served the copy at all so far.
Give him the copy.
I will serve the copy, my lord.
And
I'll take it up on Monday. Give
Please,
it to him
please,
so that
my
he'll
lord.
have instructions.
My lord, I have to file objection. My lord, there is delay in filing the application also. And in fact, in the RP.
If according to them, there is some fraud played on the court. So all these delays and all will not matter. I am going to hear this matter on Monday. Please get whatever instructions you want to get. The counsel for the petition shall serve the copy of the petition on the counsel appearing for the respondent. By Monday, the respondent shall get instructions. The court will hear the matter on the merits of it.
Copy has been served, my lord. That may be.
Yes, Monday.
Oblige.
Number 11.
My lords, for the respondent, in this matter, my lords, in fact, in this matter, the parties arrived to a settlement and the matter came to be disposed of, reserving a liberty for the respondent to withdraw the amount. However, since there is not specifically mentioned which respondent has to withdraw the amount, the matter is again posted before my lords today, my lords. So we are requesting my lords to.
The light of the already disposed of, and the amount that is lying before this court. Who are the respondents before this court?
My lords, respondent is wife and daughter, my lords. My lords, since daughter is minor, my lords, respondent number 1.
First respondent is the wife.
Please, my lords.
This petition RPFC was disposed of on 4th June 2024. 2025, and this court has disposed of the RPFC, observing that in the light of the fact that the matter is already settled, the RPFC is disposed of an amount that is lying before this court. The respondent is at liberty to withdraw the same. It is submitted by the learned counsel that the respondents are the mother and the minor daughter. As there is no clarification in the order, as it is stated that it is the respondent, they are not in a position to release the amount. As such, the present IE is filed. Hence, there shall be the order dated so and so is clarified, and it is the respond in the operative portion of the order. The respondent number 1 is at liberty to withdraw the same. The corrected copy shall be uploaded.
Grateful, my lords.
Cell number 12. Nagesh Vinay, yes.
Yes.
Appear for the petitioner, my lord.
Sudarshan RG, party in person.
On the last date of your lordship asked.
Why is it adjourned? List these matters on 30/2/2026. By the time learned counsel, the mother shall get specific instruction with regard to the overnight custody order. This court will pass orders on the merits of the matter.
Lord, as far as overnight custody is concerned, I have asked my client. However, the child has to undergo surgery in the month of March, my lord.
In the month of
March.
What surgery?
He is suffering from kidney related issues, my lord. I'll just pass on the.
My lordship, that is again after a review, it will be decided. There will be another review of the condition of the child. After that, it will be decided, and that will be in the summer months, my lordship. Maybe in the month of April or May, and until then there is sufficient time. And once there is surgery, I will not. At least I want to see my son when he is recovering. But I don't want any overnights or anything like that. I will not exercise it, my lordship.
Yes.
My lord.
No, he is a school-going child.
Please, my lord. That is the reason we have fixed it in the month of March and April, so that he will be having summer.
Still in February.
Please, my lord, because we should train the child to undergo surgery, my lord. That is the recommendation given by the doctor.
There is nothing like that given to me, my lord.
Sir, you will get your chance.
What the procedure is, let the counsel complete, then you can respond. For every one sentence you start replying, it is difficult for the court.
Too many misleading submissions, that's all, my lord.
Just wait for your turn. Yes.
Kindly see the advice, my lord, because the doctor has advised the mother to ask to review with the MRUogram to train child for double voiding and timed voiding, my lord, because mother has to instruct the child to urinate in particular time, my lord, for about 2 to 3 years, my lord. For the surgery,
Why the father can't do all this?
my lord,
If,
because,
if
my lord,
there is a plan, how he should do, what he should do, both of them will do. One thing I have an impression that mother on one pretext or the other pretext, she wants to see that father do not have the overnight custody. That appears to be the only intention of the mother. That can't be. And that is not before this court.
my lord, not
I'll
at all,
not
my
let
lord.
it.
Not at all, my lord. Even when the child is aged
If-
about 11 or
Now
12 months,
what
we
we
are giving
say is,
visitation to the father as well.
accordingly, whatever is required, there shall be a plan, whether it is with the mother, whether it is the father, both of them will take care of it. Because in fact, it is the father's concern that the mother is not giving tablets properly. What do you say on that?
My lord, this is the intention is harassing the respondent, my lord. He is not fighting for the child, my lord. He is fighting through the child, my lord. This is the argument which I am addressing from the GNWC and this case as well, my lord. Whenever, whatever, even in the to the doctors, he has mentioned that the recommendations kindly see page one, my lord, which you are given. He has made that both the parents are fighting in the court and all those things because doctor sought out family issues in preparation for surgery in the March 2026, my lord. Wherever he goes, he is just complaining about the mother, my lord. Even mother is ready to take the child to whichever the doctor the respondent suggests, my lord. Even this pediatric surgeon, he has consulted total 15 doctors in the town, my lord. All the doctors are recommended by father, my lord. Not even a single doctor recommended by father, so mother, my lord.
No, you are taking the child to the doctor as recommended by the father. You also send the child to the father.
My lord, because he is complaining that whenever the mother
What is
suggests
it-
doctor, he
What is
is
the
finding
difficulty on overnight visitation?
my lord, because considering the tender age of the child, my lord, it has become very difficult for the mother to let go the child for overnight custody for entire 2 or 3 days, my lord. Even he has sought overnight custody for during Christmas vacation, Dasara vacation, and during festivals, my lord.
What has happened in that time?
My lord, we have given overnight custody for the child, my lord.
What happened? What are the problems? What are the ill effects on the child because of the
No.
overnight visitation?
Let me submit this, my lord. The child, after overnight custody with the father, my lord, he was like, he is unable to take baths, my lord. He was like, I'll wear different clothes. I'll tell everybody that I took baths. This is what my father has trained.
What happens
Please
in
take
every
it on
case?
affidavit, my lordship.
Please wait. This happens in every case.
My lord, considering this tender age of the
Tell me
child,
something which the court will hear. Some
my
tenable
lord,
things.
it will set a precedent, my lord.
What precedent?
When the overnight custody, when it is given to the father, then we are unable to cope up with the the other things as well, my lord. Because child is also suffering from certain diseases, my lord. This is the apprehension which I am placing
And
it.
what all you are saying about how the father is asking you to take here and there, we can infer something that the father is interested in the welfare of the child.
My lord, we are not at all disputing that, my lord. Mother is always ready to considering the welfare of the child, my lord. That's the reason we are giving visitation every day, my lord. Every day we are giving visitation. Even on the weekends, from 2 to 5, he is getting visitation, my lord. Up until the completion of the surgery.
Give it on a day, and if you give it on the night time, what will happen? Night time, the child will sleep.
My lord,
What
because
will happen?
up until the completion of this surgery, it is not at all possible, my lord.
Why? Who are you to say? Doctor never said so.
Not, my lord, because the mother has to train the child for the surgery and
Can't
all
the
those
father
things, my
do
lord.
it? I'm asking that.
My lord, that's the
question.
reason we let him pass that evidence test, my lord, that he is capable to for overnight custody, my lord. In GNWC case, he is not at all leading evidence, my lord. He is filing application one of the other and getting
We've already
visitation.
discussed that he will go ahead with the evidence.
Let him, my lord,
go
any
ahead with
orders
the
passed by this court will have an impact before the trial court, my lord. It will set a precedent so that trial court doesn't, when High Court has passed any orders, trial court won't consider this, my lord.
What
Up
court?
until completion
No,
of this
or the court
surgery,
will give custody to the father.
no, not, my lord.
Because the court
Because
has granted interim custody, the trial court will grant custody to the father.
my lord, let him demonstrate.
Says so.
No, not let him
Not
demonstrate before the court. Let him lead his evidence before the trial
Let
court.
him lead.
Let him lead his
and I'll
evidence,
make
my lord. We are not at all on that, my lord.
I will make arrangement for this. It should go on. No, it is not. The boy is comfortable with the father. As long as a boy is comfortable, there is no, when the court is looking at the welfare of the child and there are no any other material before the court to say that interest of the child is impacted because of any order, this court will not stop.
Please, my lord, even the guidelines which our Honorable High Court is also framing, considering the welfare of the child, both mother and parent, father should consider the welfare of the child, my lord. Considering the medical history and the some disease which the child
Earlier
is
order,
suffering.
you have to think when the court said it is apprehension of the mother that she is not giving proper medication. Court every day asks the mother to make a video call to the father while giving the medicine.
Please, my lord, we have sent all those things, my lord, to the father.
Does
When
it infer?
apparently, my lord, even this court has ordered the father to send the videos to the mother, my lord.
Indicated my mind, Mr. Counsel. Please now come to the point.
My lord, whenever mother makes.
Not go.
My lord, this is apprehension by the father, my lord.
Anyhow, now I am inclined to grant her, this is now not listed for arguments. It is only listed to get instructions. Now your instruction or your client is not ready for a overnight custody for these reasons. I'll record that.
Please, my lord, let it be recorded, my lord, because considering the surgery is in the month of March,
Yes, I'll
up until
record.
completion
I'll
of the
record, I'll
surgery,
record.
we'll make an attempt to see that.
Yes.
My lord, one small submission.
Yes.
Regarding the medical health condition, I was the one who was taking the child to the doctor. And even when I asked my wife to take him to the doctor, she said, you get a court order. IA number 9 was filed. That is part of my annexures list in the affidavit filed on 10/10/25. I'm deeply hurt by the misleading submissions, my lord. So that's my small.
My lord, that is the reason I mentioned the doctors which are suggested by father. We have taken the child to that doctor as well, my
Come
lord.
to the impugned order. In the first writ petition, I'll look at the review later.
Yes, my lord.
Where is that writ petition?
So, 14503.
One,
Impugned
two.
order 14503.
14503, give that.
The impugned order is on page 8 in the writ petition.
Come to that order.
Page number 45.
Page number?
45. Operative portion is at page 44. It starts from 44.
Petitioner father is entitled for interim custody of the minor child between 2 p.m. to 6 p.m. on every Saturday and Sunday, and he shall pick up the child from respondent mother's house and drop him back. Petitioner is also entitled for interim custody of the minor child on birthday of the child and during all festivals from morning 10 a.m. to 2 p.m. and he shall pick up the child from respondent mother's house. Petitioner has a right of contact with the minor child on alternative days through video call for a period of 1 hour in between 5 p.m. to 7 p.m. with prior intimation to the respondent. Who has filed this writ petition?
We have filed, my lord. We have challenged only the as far as video calls
Have
are
you challenged this order?
Yes, my lordship.
That is
in
writ petition number?
14353. WP 14353, my lord.
14353 is and 15503 are connected.
14503.
What is your application?
My lordship, my application is to grant overnight custody on weekends. Let me read the.
Let us look at your IA. Where is it? Which page number?
Just for prayer. Yes, my lord. That is on
71.
page number 98 in 14503.
Page number?
98, my lord. Annexure E, the first page of Annexure E.
I'm looking at his documents. WP 4503 I'm looking at.
Yeah, 14503. In that page number 98, ink page number 98.
Please permit the petitioner to have minor son so and so. It is 2 p.m. to 8 p.m.
No, my lordship. From 5 p.m. on Friday till 7 p.m. on Sunday is the overnight prayer.
Friday and 7 p.m. on Sunday. Festivals and on the petitioner's parents. So now you are agreed as far as not granting the overnight custody.
Overnight, my lordship. Now the daily visitations are going on fine, my lordship. Because of that, we have also stopped the video call because that was at inconvenience to the mother. Let that continue, my lordship. In addition, the weekend, overnight, anything that court grants, I will be.
Even you are agreed by which order? Which part of this order?
Video calls, my lord. Video calls from 5 to 7. In turn, it was modified by giving physical visitation to the father every day. Video calls has been stuck down. We are giving everyday visitation to the father and weekend custody from 2 to 5. Every weekend we are giving the visitation to the father is exercising the same, my lord. However, this overnight custody was rejected in this application. Then he filed another application before the family court, which in turn gave 50% overnight custody to the father. That have challenged in 30128.
That is which writ petition?
30128. 30128 of 25.
That is for the vacations, my lord. That is for the vacations, school vacations only.
Even in this, he has sought for overnight custody of the child, interim custody.
That because of in view of that order in that writ petition, It is already now, he has exercised his station.
Please, my lord, he is getting
For how
visitation.
much time?
Every day from 5 to 7. 5 to 7 and weekend from 2 to 5. Saturday and Sunday.
Overnight custody during 50% of the visitation.
Please, my lord, overnight custody, this court made an arrangement. He has got overnight custody for 5 days, my lord, during
No, it is
Christmas
again
vacation.
false, my lordship.
5 days or 4 days?
Okay.
Let me correct it, my lord.
You don't say for everything false. You clarify it.
Yes, my lordship. It is false. That's why I said it is false.
Don't have to say that.
Okay. Yes, my lordship. So that vacation custody has been under stay, my lordship, because there is a pending Niman's evaluation report. I am ready to go for the Niman's evaluation. The mother is not accepting it. Because of that, I have lost.
Vacation, I have passed one order.
Yes. Now I have got only 2 nights during the New Year's Eve, my lordship. 31st
Yes.
and 1st, I got 2 nights.
Yes.
That's it.
Please come. First of all, I'll pass one order in this writ petition. The present writ petition is filed. The agreed with award order passed in I number 3 in GNWC number 349 of 2023.
It is IA number 4, my lordship. It is IA number 4.
IA number, what is IA number 3?
That is for the full interim custody during the pendency of the case.
All
IA
this
number
petition
agreed
got
with orders
disposed of,
passed in
disposed of on 26th June. Now he has filed review application in these writ petitions.
in 14514.
Please, 1450.
And your writ petition is still pending with the same order.
Please, ma'am.
Agreed with the order passed in I number 4 in GNWC number 349 of 2023, dated 23rd April 2025. Both the mother and father are before this court. The father's writ petition is WP number 14353 of 2025, and the mother's writ petition is WP number 14503 of 2025. The court had passed an order in the writ petition as follows at page number 43. Please extract the operative portion of that order. Initially, this writ petition 14353 of 2025 was disposed of by this court. Where is that order sheet?
26/6/2025.
14503 order sheet. Order sheet. That is disposed of order is there. No, next it is. This court on 26th June has disposed of this matter. That is WP number 14503, 14353, 14361 of 2025, wherein as per the order, operative portion of the order reads thus. It is at after paragraph number 9. Extract all that operative portion. Thereafter, the father is before this court. The father has come before this court as a party in person and sought review of this order. The same was opposed by the learned counsel for the mother, stating that when the court has passed an order hearing both the counsels, now the petitioner has not made out any ground for reviewing the order. It is submitted that he has argued at length, submitting that this review petition is not maintainable, and it would not, in none of the grounds that are stated, the reasons that are stated cannot be the grounds to review the order. The party in person, it is the contention of the party in person that when right from the beginning, when he is insisting for the overnight custody, and as the same was not put forth before this court, by the council, which has made him to come before the court in the matters pertaining to the welfare of the child and also matters pertaining to the any matter that is pertaining to or revolves around the child. And while this court exercising the parent patria jurisdiction, the technicalities will not come in the way of the court, and court would appreciate the facts, looking at the holistic in a holistic approach, balancing the interest of all the parties. In the order, while passing the order, this court has specifically observed that whenever the medicines are given to the child in the morning and in the evening, considering the health condition of the child, the mother can record a video and send it to the father. And the court has passed order with regard to the festivals, where the father, festivals that are celebrated in the family, he can have the visitation from 10 a.m. to 2 p.m. And when it comes to the video call, that it is very difficult for a boy of what is the age?
3.5 months.
3.5 years to call to speak to the father on a video call from 5 p.m. to 7 p.m. It is modified as long as the boy is comfortable. And the father shall be informed about the school activities. Then counsel, the party in person submits that, father submits that they're living in a close proximity of
450 meters.
450 meters. The boy is very comfortable with the father. And the boy, right from the beginning, is very much involved in the activities and the welfare of the child. And if overnight custody is granted, it would not be, no adverse effects would have on the child.
My parents also live with me, grandparents.
The grandparents also live with him. In this review petition, this court had interacted with both the mother and the father. The mother has raised certain issues, saying that father requires is emotionally not stable, and according to the father, mother is not stable. And then this court on 23/9/2025 has passed an order saying that, observing that both the parties shall appear before the doctors at Nimhans on 16/10/2025, and the doctors shall evaluate both of them as per the advice of the doctors, that the party shall go through the therapy sessions. Once the evaluation is done, the doctors at Nimhans shall send the report to this court. In the meantime, from Monday to Saturday, the father can pick up the child from the mother's place at 7 p.m. and drop him back at 9 p.m. And the father is entitled for the interim custody of the minor child between 2 p.m. to 6 p.m. on Sunday. And the Saturday-Sunday arrangement can be adjusted as per the convenience of the parties. Thereafter, when the parties have appeared before the Nimhans has sent a report to this court that the parties cannot be evaluated as outpatients and they have to admit as inpatient. The mother is reluctant to admit as an inpatient. And according to the doctors, the evaluation is not possible.
Even outpatient, she said no, my lord.
For inpatient, entire 1 month, my lord.
That's what. Inpatient, she can't.
For entire 1 month.
Outpatient is not possible according to them.
Outpatient for 12 months, my lord. 12 months to 18 months.
Outpatient, it has to be for a year.
Even that she said no, my lord.
Huh?
Even that she said no.
No, my
This
lord,
is
not at all, my
important.
lord.
For a
Please
year.
allow me to submit. Even in the Supreme Court SLP, this fact has been completely suppressed, my lordship. So some other day, if any reliefs favoring me come, this may be coming up in the future also. So kindly this be recorded that I was willing to participate. Even on today, I am willing to
The father is
participate.
ready to.
No, even mother is
undergo.
ready, but considering the tender age of the child, unable to admit.
Let me complete. You will understand what the court is saying.
Because my submissions were
I'm
recorded.
only making submissions what are there on record. The The mother, the father is interested both as an outpatient or inpatient. The Niman, according to the doctors at Nimans, as an outpatient, the treatment takes more than 1 year, and as a inpatient, it will be for a period of
1 month.
For 1 month. According to the mother, it is not possible for her to admit as an inpatient and
Inpatient, considering the tender age of the child.
that is anyhow I said.
Because
What
she's
about
get-
outpatient?
Outpatient, she is ready, madam.
Outpatient, she's no, then now I'll pass an order, go for 1 year.
My lord, 1 year, my lord, it is difficult for her to travel for
That's what
entire
he
1
said.
year, my
What
lord.
is wrong in what he said?
Please, my lord, because considering the tender age of the child, because she cannot leave the child for entire 1 month with her
Now,
grandparents and
whatever
admit
are
for
the
a month.
consequences, you are neither as an inpatient or an outpatient, you are not interested because of the tender age of the boy and your difficulties. That is correct.
Please, my lord, only
That's
considering
what
the
he
age
is
of the.
submitting. That's what he is submitting. You said not correct.
My lords, please,
It is stated that the mother either as an inpatient or an outpatient, as outpatient is for more than a year, inpatient for 1 month, both of them are not, she cannot go ahead as looking at the tender age of the child and
small,
also the fact that she has to take care of us. She has to go for her work.
No,
and
my lord.
also
No, my lordship, she is not, she's a homemaker.
Please, my lord. She earlier point of
take
time she
care
was
of the
working
child.
because
As
child is
such,
3 years.
please wait. As such, it is not possible for her. And then
Small.
court has passed an order.
My lordship,
Then in the meantime, which is that order in that writ petition? Where some of its station was questioned, the holiday vacation was questioned. Which writ petition is that?
that is 30128, my lordship.
30128.
30128.
Give that 30128.
Lordship, Niman said child can also come. That is there in the report
Huh?
also. Niman's doctor said the child can accompany, and in fact, it is essential for the child to be there.
30128 of 2025. In the meantime, IA number 8 is filed before the court, whereby the father has sought for 50% custody during summer, Christmas, Diwali, and other vacation or holiday, more than a day, which school declares every year, and 100% custody during Dasra vacation. In that, the court has passed an order. Look at it at page number 36 of WP number 30128. Extract that portion of the order. Questioning this writ petition, questioning this order, the mother has filed WP 30128 of 2025. This initially came listed before a coordinate bench of this court on 39/2025, where the mother is directed to keep the child before the court on the next date of hearing. Then on 3/10/2025, an order was passed. Considering the order that is passed by this court in the review petitions, the court had directed that the visitation that is granted as per by this court in the review petition shall continue. And this order is stayed.
Please.
And the order passed in I number 8 is
13.
stayed by the
I number 13.
I number 13 is stayed by the court. Thereafter, again the matter was listed before this court on 17/10/2025. This court passed an order, extract that. Then on 25/10/2025, This court has passed the order. Fifteen 2025. Order also extract. Again, is this order the respondents have approached the Honorable Apex Court by filing
37227
that
SLP.
SLP order.
That is in the memo of SLP, my lordship.
If you have a copy of it, please pass
Yes,
on.
my lordship.
I think last time he
SLPC
has
is right
passed
here,
on
yes.
that order of the Apex Court.
Yes, my lordship, it's here.
Take that. The same was carried in before the Honorable Apex Court by filing SLP number 'There is no order copy here.
It's there, my lordship. It's in the fourth page. Third or fourth page, my lordship.
Number 3. 37727, 37728 of 25.
Yes, yes, it is there. Thereby filing SLP civil number 37727 to 37728 of 2025. Then the same was dismissed by order dated, which is order 19/12/2025, wherein the Apex Court has observed that after hearing the senior learned counsel, we are not inclined to entertain these special leave petitions. Accordingly, the special leave petitions are dismissed. Thereafter, the mother has given the overnight custody to the father. It is the case of according to the father, the visitation went on very well, and the boy is very much interested to spend the time. On the last occasion when the matter came up, it is submitted with the party in person that as he has come during the new year, he was asking the father that when will be the new year. Then on the last occasion, this court has asked the learned counsel appearing for the mother to get specific instructions with regard to the overnight custody, considering that further orders will be passed by this court. Today, learned counsel has placed before this court the consultation with Narayana Health, here it is, Center, wherein that the advice is sort out family issue and prepare for surgery in March 2026. Open ureteric reimplantation of duplex system. Placing this before this court, learned counsel submits that the mother has to prepare. They have given certain instructions to the mother, and the mother shall prepare the child for the surgery in the month of May. As such, in the month of March. As such, the overnight custody is not at this stage. She is not ready for a overnight custody, and the visitation as it is going on, it shall go on. It is the submission of the counsel that if this court passes any order for a overnight custody, that would prejudice the case of the mother before the trial court. And as the High Court has granted the order, while deciding the GNWC petition, that would have an impact on the trial court. The party in person, the father submits that he has been all through as per the father's advice, and whenever he is asking to take to a particular doctor, she is taking the child to the said doctors, which makes it very clear, doctors. It is submitted that the father will take care of the child, how the doctor advises. Further, he will not like once at the time of surgery and all, and during the recovery period, he would not be asking for a overnight custody. And as long as the before the surgery and after the surgery, the court may pass an order granting overnight custody to the father. Next para. Having heard the counsels on either side, there is the material on record. The boy in this case is aged about 3.5 years.
3.5.
3.5 years, and who is suffering with a kidney related problem. Both of them, both the mother and father, are staying in a distance of 450 meters. The father is a well educated person and staying along with his parents. The counsel appearing for the mother, it is not the case of the mother that the boy is not interested to stay with the father. The problems or the difficulties that are expressed by the mother cannot at all be the grounds for this court not to grant visitation, overnight custody, visitation to the father. This court, while exercising the parent-patria jurisdiction, has to look at the ultimate well-being, welfare of the child. The child requires affection of both mother and attention of both mother and father, particularly in a situation where the boy is suffering with health ailments. Mother is a housewife. Father is working. In the considered opinion of this court, balancing the interests of the father and mother and also the welfare of the child is essential in the facts and circumstances of the case. By virtue of the order that is passed by this court during the vacation, the father has exercised the visitation, and any incident which is not in the interest of the child is nothing is placed before this court. In these circumstances, this court can safely conclude that the interest of the boy is not affected. The interest and the welfare of the boy is not affected if the overnight custody visitation is given to the father. Then coming to the submission of the land counsel for the petitioner mother, that any order that is passed by this court granting overnight visitation will have an impact on the pending JNWC. That submission this court is not able to appreciate. While granting custody, the court will looking at the age and the other relevant factors, the court will consider whether the father is entitled for custody of the child or custody visitation of the or interim custody of the whether he is entitled for the custody of the child, and any issue pertaining to the child will never attain finality, or it has to be viewed periodically looking at the welfare of the child. In the considered opinion of the court, the child having a child to spend time with both the mother and father, and the involvement of both the mother and father in the welfare of the child is in the interest of the child. In that view of the matter, this court is passing the following order. Give that order sheet. This is in the other one. 1-3. This one 1-30128. In the light of the above discussion, the order passed by this court in WP's number, the number so and so, that is WP number 14503, 14353, 14361 of 2025 is modified. modified. As far as clause number 1 is concerned, that remains to be the same. Two, 3, delete 2, 3. Four as it is, 5 as it is, then 6. Considering the fact that the boy is comfortable with the mother, no, with the mother, and they're staying in a close proximity. The father on every Saturday from 10 o'clock in the morning to Sunday 10 o'clock till Sunday till 10 o'clock, the father shall have the overnight custody. What about the day custody that is decided?
Every day now, the consider the child is 3 years, my lord, it is feasible for the mother to give the visitation, my lord. When the child goes to some other schools, tuition classes or dance class, some extracurricular activities, it is difficult for the
Father will take whenever
that
his
is,
time
we'll
is
keep
there.
it alternative days, my lord. At least
No. I'm asking. This is about the overnight custody. What was the order with regard to the daily visitation?
5 to 7, my lord.
Where in which in the
That
same
was modified
order?
on the 15th, my lord. 15th of
in
December,
14503.
1512, it was modified.
1512. Oh. Father can have the visitation every day between 7 p.m. to 9 p.m.
That was the before. Then they said they need a modification. Point number 4 on page number 9.
It is modified from
15th,
5
it is
to
not
7.
5 to 7, my lordship. It is modified to visitation between 5 p.m. to 7 p.m.
5 p.m. to 7 p.m.
Now that 5 p.m. to 7 p.m, my lord, we'll just make it to alternative days, my lord. Because now he's getting overnight custody on Saturday. Let me keep on Monday, Tuesday, or Wednesday, or Thursday, Friday, mother will be getting. Then Saturday he'll be getting
My
overnight
lordship,
custody.
for me and for my son, he's a 3.5-year-old child. Early childhood is the foundation for him for his entire life. Having frequent daily visitation, let it continue, my
No,
lordship.
5 to 7. It's a time where he plays. Now mother will also get a break. Father will see that the boy plays, even if he's in the house. That's the evening time where the children wants to play.
My lord, when father is not exercising visitation, it has become difficult for the mother. He'll inform at 4:30 or 4:45 p.m, my lord. That is not exercising visitation and all those things. Let him be clear, my lord, because mother has to plan accordingly, because it has become difficult for the mother to take the child anywhere out, my lord, because she has to give visitation every day, my lord.
So you have to ensure that every day 5 to 7 you have the visitation.
My lord,
Of
she
course,
cannot.
I have never missed my lordship.
My lord,
And
even mother
I
cannot take the
inform
child
well-
to anywhere else, my
Yes.
lord, because every
Yeah,
day is
allow me,
getting
sir.
visitation. Mother cannot take the child anywhere.
The
From morning
father-
to afternoon, he'll be
but the
attending
father
school.
will have the visitation between will have the everyday visitation, that is from Monday to Friday between 5 and 7. Sunday you will not have.
My lordship, the Saturday 5 p.m. to Sunday 5 p.m. would be the overnights, my lordships. Instead of Saturday 10 a.m. to Sunday 10 a.m., Saturday 5 p.m. to Sunday 5 p.m. would be ideal.
My lord, mother
Saturday,
cannot take the child anywhere else, my lord, because Sunday at least she should have.
Is she a working woman?
My lord, because child is going to the school, my lord. Even she is remain in the house because she cannot skip the school and take the child to somewhere
Can
else,
I
my lord.
propose
Because
something, my lordship?
weekend visitation, even she should
Very
get, my lord.
unreasonable, Mr.
My lord,
Counsel.
because
Very
when can-
unreasonable. What your submissions are.
when can the mother take the child
My lordship,
outside
a
to the?
small addition here,
Then
my
we'll
lordship.
he'll have on Friday to Saturday. You have a working day on Saturday.
No, my lordship, I can take
Lord,
either
we are not
Friday
aware
to
that
Saturday
where he
or
is working, when he is
my
working,
lordship,
my
at
lord.
least if he allows me to submit.
Take him on Sunday. That's what you're asking.
My lordship,
Lord, that is, we'll take on Sunday. My lord, now he is submitting that from Saturday 5 p.m. to Sunday 5 p.m, my lord.
So how it should be?
My lord, from Saturday
Tell.
10 a.m. to Sunday 10 a.m.
So whatever, because you're appearing for the mother, whatever the father asks, we should say no.
My lord, every day when the
Friday-
father gets the visitation,
Friday,
where
5
can the mother take the child
Friday
outside, my
5
lord?
p.m. to Saturday 5 p.m. Mother can take him on Sunday.
once
The-
more,
Every day
my lordship,
visitation,
here,
even
it will be
evenings, my
beneficial
lord.
for both of us if he
Lord,
allows
every
me
day
to submit.
visitation, if father takes the child, my lord, mother cannot take the child to anywhere else, my lord, because from morning to
I
afternoon
will-
he'll be
I-
going to the school, my lord.
I have a
Afternoon, when he
constructive
comes back,
proposal.
then she has to
My
feed her
lords
and
can-
make her write homeworks and all
Both
those
of
things.
you
my lord.
argue, I have to stop the order here.
Constructive proposal, my lordship. I understand mother also wants to take, my lordship. Let her take.
When?
Following week, for entire week, if she wants to take, let her take, let her go to Hubli, wherever she wants to go. Let them compensate it for the following week, my lordship. Same thing, if I have to travel outside, my relatives have not even seen my son. 3.5 years, they don't even see
Please
the...
don't go to that
No,
proposal now.
no, that's what. If
That
there is a
support will not
2-day...
grant it now.
Okay, okay, my lordship. Then
Don't
what?
let your, you see the child, let your relatives may not see. If they want, come to your house and see.
Okay.
On Friday, between 5 Friday to Saturday 5 p.m. That is overnight custody. And on all other days, Monday to Thursday, he will have, Sunday I'm not granting. Monday to Thursday, between 5 to 7, father can exercise the visitation.
My lord, at least it will be on Monday to Wednesday, my lord. Because Thursday evening she has to, she can take the child to somewhere else.
Where is that, with regard to the overnight custody, where is that order? Where is the order? Overnight custody, page number?
In the 30128, my lordship.
Order of the court.
That is, I think it is on page 30. One second, my lordship.
36?
I think so, yeah.
Starts from 36, operative portion is at 37.
The petitioner, the father, shall have the 50% of the Dasara, Deepavali, Christmas and summer vacation as per the convenience of the parties. They can have either the first part of the vacation or the second part of the vacation during the set period. How was it spent last time? 5 days?
First of he exercised.
No. How was it? The entire 4 days he was with the father.
No, alternative days it has made. 3 continuous days he was with.
My lordship, 2 days it was overnight. 31st and 1st overnight was there.
3 days.
2 days morning 10 a.m. to evening it was there. 10 a.m. to
Then
6
we will
p.m.
do something like this because it's too small. Continuously you can't keep him.
Sure, my lord. My lordship, he is actually quite happy, and my parents are also.
When the child grows up, my lord, we'll give the visitation to him, my lord. Considering tender age, only my submissions
We
are
can do
placed because of the
weekly
tender
exchange,
age.
my
Lord.
lord.
When the child grows up, we'll always give the
Something in
visitation.
your favor, you please listen.
Please.
I'm saying something in favor of your client. What I'm saying is when we say about 50% of the visitation overnight, when you're talking about it, we'll say that it is not the entire 50%. It's alternative day. If father is having on a Monday, the mother will have Tuesday, like that.
My lord, what will happen?
Or if you want to take the child and you're going consecutively for 4 days, then later after coming back, you will give him that consecutive 4 days.
Please note that interim arrangement will coordinate with each other and will.
When the court is referring to the 50% of the vacation, considering the tender age of the child, this court is of the view that it should be the father shall have the alternate days overnight custody, and during that visit, during that vacation, if the mother wants to take the child out of Bangalore for
excursion
for 3 or 4 days, once after she comes back, there should be consecutively the visitation shall be given to the father.
My lord, one small, whenever she travels outside, my lordship, the video call, let it be there, because now
While the mother is traveling, there shall be the father is entitled for a video call as long as the boy is comfortable. Accordingly, all these petitions are disposed of.
much obliged.
And one more thing, let him
And one
lead his
more,
evidence before.
the respondent, without filing unnecessary applications before the court, shall cooperate with the trial in the pending GNWC.
Please.
Next.
Yes, my lord, I'm for the petitioner in this case, my lord. In this case, my lord, I challenged sale notice and section 14 order, my lord. Liberty may be given to approach DRT, my lord.
Writ petition is filed seeking the following prior.
They have already approached DRT.
Already approached.
In
What is
sale,
that liberty?
no, my lord, sale notice are challenged, my lord, not section 14 order. For that, liberty may be given, my lord.
The present writ petition is filed seeking the following prayer. Land counsel for the petitioner submits that questioning the sale notice, they have already approached the DRT. Questioning an order
Yes,
passed
madam.
under section 14, liberty may be given to the petitioner to approach the DRT. Accordingly, the writ
My
petition
lord.
disposed giving liberty to the petitioner to avail the appropriate remedy in accordance with law. Yes, next.
My lord, time prosecuted in the High Court, it may be condoned, my lord.
Why are you spending unnecessary time in the High Court, and why should we grant you that the section 14 of the Limitation Act?
No, my lord, but petitioner is ready to settle the issues, my lord.
What will happen is any 14 limitation will inure to your benefit. Yes.
Serial number 14, Prithvi Vadayar.
Yes.
Last occasion, your lordship had permitted me to file a detailed objections, my lord. Objections are ready. I have served the copy on the other side.
Today I have received. I'll just go.
You want time?
I want time. I have
Monday?
received today.
Monday?
Survey.
You want a long time?
So we
List
have
after 2
this.
weeks. List after. Huh? The counsel for the petition, the counsel for the appellant shall serve the copy on the counsel for?
2 and 3.
Respondent number 2 and 3. Yes.
I'll point out, my lord, they are abusing the process of this honorable court.
No, whoever is abusing, they will face the music. That much I'll make it very clear.
Because, my lord, respondent number 1, defendant number 1, he was the sole defendant. He gives an undertaking as if that he will not sell the property. But in the meanwhile, he has gifted it to his son, who is the defendant number 2. This defendant number 2 enters into a GPA with defendant number 3, who is the review petitioner before my lords.
No,
only
whatever-
one person gives undertaking.
Whatever, listen to the court, whatever anyone has done, and whoever has come before the court, either you or he, if the court finds that
We have
any
abused the
fraud is
process.
played on the court, I will impose exemplary
Yes,
costs. I'm making it very clear, 10 lakh costs for anybody.
Yes.
Yes.
Any date, my lords.
It will come on, it will come in the month of March, maybe list the matter on.
Lord, because
12th
they are
of-
citing this review petition and not permitting to move in the contempt, because they have, in violation of your lordship order, they have executed sale deeds. Now they say they say.
Can you wait, you can wait till 12th of March, because so that by the time I'll come back to.
Please.
12th March. Yes.
Grateful members.
Serial number 15, preliminary hearing B group. Keshav Bhatt.
Petitioner and the respondent number 2.
FF for R1. FF for R1.
Yes.
Respondent number 2 seeks for some time, lord. Objections are ready. He has.
Please understand first of
Please,
all, what is his case? Please come to the prayer. What are you seeking?
Mandamus, my lord.
Mandamus?
Petitioner and the respondent number 2 are the director.
Issue a writ of certiorari, any of it directing to set aside the communication. What is a communication by the bank?
That is, the petitioner has deposited rupees 55 lakhs towards the.
Is it, can a mandamus lies against that order?
Sorry, no.
No, you will come to the court only in the SARFAESI proceedings, isn't it? No, if you have any grievance against the bank's ombudsman or somebody, there is some mechanism in place that you will go. Even court will enter
I
into
will
bank
submit the
and
facts,
the
madam.
borrower's transaction.
No, I will submit the facts, my lord. Brief facts, my lord.
Whatever are the facts, is it a writ petition maintainable between the transaction of the bank and you?
The only thing is,
Only
my
the
lord,
court
I
will
am seeking
entertain,
for
court is
refund.
only entertaining on SARFAESI, an act arising, the proceedings arising out of a enactment.
No,
Not on day-to-day transactions of both.
May I just.
I am seeking for
Yes,
refund.
One Sound Shelters Private Limited was a company. It stood as a corporator guarantee. Petitioner, my lord, and the respondent number 2 were the 2 directors. The property belonging to Sound Shelters Private Limited, my lord, was sold in auction. And a third party bought the property, my lord, in the auction. When the property was being handed over, there were some movables, my lord, inside the property which belonged to the corporate guarantor company, that is the Sound Shelters Private Limited. The movables, my lord, were directed to be removed. One of the directors, my lord, the petitioner herein, he came forward, he, my lord, deposited certain amounts, my lord, according to him, according to the respondent number 2, that is the company's money. And that deposit, my lord, he is seeking for refund. As on that day, my lord, that is during 2019, the movables, my lord, were valued at rupees 55 lakhs. The movables, my lord, admittedly it belonged to the company, which was the petitioner and the respondent number 2 are directors. In view of that, my lord, the movables, my lord, are with the petitioner. Recently, my lord, during December, my lord, I am made as a party second respondent, my lord. My objections are ready. I have a medical condition with limited movability, my lord. I am surviving. That too, my lord, I have lost 40% of my memory. That's why, my lord, everything is ready. By Monday, I'll place it on record. Any money which is in deposit, my lord, before the bank, it has to be equally divided, my lord, among the petitioner and the second respondent.
Who has paid the money?
It is,
The
my lord,
petitioner paid the money, my lord.
as against, my lord, the receiving of movables.
No.
As against receiving of movables, the petitioner has paid. The value of movables, my lord, was 55 lakhs. That was admittedly belonged to the company.
He has taken that.
He has taken that.
And he has
why-
deposited 55 lakhs with the bank, my lords. The bank said, you are at liberty to take the movables, but you have to give a guarantee because he was the only director who came forward at
that
the
is all.
time when we communicated him to remove the movables, my lords. So he deposited 55 lakhs and he wrote a letter asking us to give the money in March of 2016.
Then after that, where were you?
My lord, I had suffered, my lord, a medical condition. My lord, I had suffered paralysis, my lord, for the,
How many are the directors?
only 2 directors. During 2014, my lord, I suffered, my lord, paralysis for the entire body and also to my lord mind. Only with limited mobility.
You out of that 55 lakhs, sir.
We both are equally entitled. That is all. The property, my lord, was admittedly belonged to the company.
Lord, I have paid the entire amount in my personal capacity, my lord.
Not about the money.
You have paid the entire money in your personal capacity,
my lord.
but the property is not your property.
Oh, he was disqualified from the directorship, my lord, during that time. I have produced that annexure C, page.
So how
15,
all
my lord.
these disputes, how can we decide? Whether he is disqualified from the directorship or not?
But my request is, my lord, kindly have it on Monday, my lord, seniorly.
Yes.
In the meantime, I will also file my objections. It may kindly be taken up on Tuesday, my lord, if not.
Lords,
It's
Please,
not
Monday.
possible.
one last submission.
Monday.
Yes.
With permission, my lord, to file the objection in the open court because he has, my lord, some problems. That's why. Please.
Give them a copy before.
I'll send a copy. Please.
Yes.
Cell number 16 adjourned. Cell number 17, Rajeshwara PN for petitioner.
Last time also it was adjournment.
What happened?
Actually, it does not survive for consideration, my lord. 16, last time also.
What happened? What happened to?
They
16?
challenged the interim order granted by the DRT.
When is it posted?
That he is not fitting well with the appears to reach and submitted.
Oh, so
Last
I
time
will-
also same thing is did, my lord.
I posted it to Monday, I think. Monday, it will come on
It
Monday.
does not survive for consideration.
Monday.
That's what, my lord.
That is what you can tell on Monday. He said he has some personal inconvenience and he has informed to you also. That's what is informed.
Got it.
Huh? Monday.
Yes. Number 17,
Petitioners for respondent.
Rajeshwar PN.
This matter is regarding releasing of security documents taken as security for repayment of the outstandings, my lords. So they had proposed for a one-time settlement and we had paid the whole amount, and because of the delay, we had also paid penalty regarding that, my lords. Now they are not ready to accept the same, and they have.
Have you filed your objection?
Yeah, I filed a detailed objection. Also, OA is pending before DRT.
One. Let us look at the events.
See my documents, page number 43.
So 24 to 2022, the OTS scheme was confirmed.
Yes. Yes, ma'am.
On 19/3/2022, petition has deposited 3,70,241, 10% of the OTS amount.
My lord, see my documents, page number 43, OTS letter.
Any interim order in this?
No, my lords.
Where are your objections?
Objection and documents are filed, Your Honor. Page number 39.
Now, what is he seeking? To direct the respondents bank to issue no due certificate and release the security deposits. According to them, the entire amount is paid.
Paid, Your Honor. Paid. So that's why I coming to the documents. Page number 43, Your Honor.
Now, before looking at the document, shall we look at your objections first?
A file objection also filed, Your Honor.
Let's see the objection, which paragraph?
On or before 23/8/2022, he has to deposit 37 lakhs.
One
37 lakh 2,402, Your Honor.
Where did you say so? Paragraph number?
No, paragraph, documents. As OTS letter has given, bank has given to the petitioner.
Page number?
Page number 43, Your Honor. My documents.
Yes.
We refer to your letter dated 21/2/2022 for settlement of your dues to the bank under the caption of CAF scheme. We are pleased to advise your application under the caption scheme has been accepted by the appropriate.
Find it at the page you are saying.
43, Your Honor.
43 is Debt Recovery Tribunal, cause title.
My documents, Your Honor.
Yes. Please.
Respondent. Sorry, Your Honor. Their document, sorry, their document.
Their document 43.
There.
Yes.
OTS amount payable under the OTS scheme will be of rupees 37 lakh 2,402. Application money in or nil paid by you will be appropriate towards your OTS amount. 10% OTS amount will be deposited by you first installment within 30 days from the date of sanction of OTS.
When was the OTS sanction? Your
24 to 2022.
24?
To 2022.
2022.
Yes, sir.
So by 24/3 he has paid that amount.
Yeah, 10%.
10%, that is some 3 lakhs odd.
Yeah. Fifth column error. The balance amount to be paid within 6 months from the date of sanction, the valid period, together with interest 6 months. MCLR 6 months, tuner.
Either 10% of the amount within 60 days. Then that 60 days is 24/5.
Yeah.
2022 he has to pay 10%.
Yes.
Then thereafter, the balance can be paid within 6 months on the date of sanction.
Yeah.
So that is from
23/8/2022 is end.
6 months is 24/8/2022.
Yeah, yes, sir. Here's his 64. See the documents on page number 64, statement of account is statement.
1 minute, 60?
64.
Instead of doing all this, if you state it in your objections.
Yeah, everything I will placed on record.
Let's not go to that. Come to your objection.
No. The page number 64 only. Last 64. Statement of account.
Yes. Yes. Yes.
Just 1 minute. Thank you.
That's why I'm asking you to refer to your objections. You must have stated all this. What is the difficulty?
28/11/2022, he paid 12,18,731 after lapse of page number 51. Sorry.
51 of what?
The statement. This petition.
His petition or your statement?
Petition document.
Yes. Let's not go into all that. Please don't confuse the court. Come to your objections. Where did you say about the payments? That is the purpose of asking you to
Yes,
file the objection, not to look at all these documents.
Yes, sir. Page number 8, my objection.
Yes.
As per OTS scheme 2022, petitioner agreed to pay 37 lakh 2,402 on or before 23. But the petitioner not paid 37 lakh 4,402 petitioner paid only of rupees 21,54,512 as OTS agreed on or before 23/8/2002. Remaining amount 15,47,000 was not paid petitioner on or before 23/8/2002.
When he paid that?
Yes, sir.
When he paid that 15,47,887?
After 44 days, my lord. After 44 days from the date,
Yes.
with the penalty we have paid.
Yes.
He is defaulted, the bank also filed OA. Your Honor. OA amount is OA copy also produced before this honorable court. Page number 43 of my documents. Claim amount is
No, he has already paid the penal interest also for that.
once it is over, INR before OTS scheme, it is not applicable to, as per his scheme, is not applicable. Is more than 1 crore is there outstanding dues. Your Honor. Is not paid within 23/8/2022.
In any of the cases, banks never extended?
No, Your Honor.
Never?
Never. As per my knowledge, never extended.
Is it a correct statement?
Yes, sir.
Or you need to get instructions on that?
No, Your Honor. My knowledge is never extended.
You're not on knowledge, it is about your instructions. Now, he has paid the entire amount. The only difference is 44 days. Entire amount is paid with penal interest. So, what is the stand of the bank? Please tell. Please come. According to the petitioner, as per the one-time settlement, he has paid the entire amount. However, when it comes to an amount of rupees 15 lakhs, he has paid it after 44 days from the date of, from 6 months from the date of the scheme with the penal interest. Land counsel for the respondent bank shall get specific instructions, and whether in any case, the bank has ever considered has accepted the payments beyond this OTS scheme. Yes. It should be on an affidavit. By way of an affidavit, it shall be filed.
Get the
This is-
instruction.
No, instructions will not do in this. An affidavit before this court with regard to this. This is matter on 3rd of March.
Till number 18.
Correspondence council.
Very good. Petition.
Mohan Das Rao.
What is that?
Serial number 18. I'm withdrawing the petition.
They challenged sale here. Subsequently, they went to DRT, same cause of action. That is dismissed. Now they are withdrawing this writ petition.
The present memo is well seeking to withdraw the petition. Land counsel appearing for the respondent submits the questioning the very same. What is this? What is this question?
Sale
Sale notice was questioned before the DRT, and the DRT has dismissed the
SA number 99 of 24.
99 of 2024 by order dated
Order dated 28/2/2025.
28 to 2025, and the petition is now withdrawing this writ petition. Be that as it may, considering the memo filed before this court, the writ petition dismissed as withdrawn. Yes, next.
Till number 19.
19 or
First.
20?
For the petitioner.
Till
Lord,
number
I'm
19.
filing.
Fazil Ahmad.
I may be permitted to file objections, my lord, because this relates to a mortgage which is a prior mortgage to their sale. And they have sought for mandamus.
What is this writ petition? First,
Yes,
let
my
me
lord. Yes,
understand
ma'am.
the facts.
Yes.
Directing the respondent bank to break open the seal affixed on the petitioner's scheduled property, which is sealed by the respondent bank. According to them, there is no relationship, there is
Yes, my
no, they have not borrowed the money.
They have not borrowed from us. They have borrowed from some other bank, my lord. But then we are on prior sale and prior mortgage. My lord, their date of sale is 3/1/2020.
This property.
My lord,
Who has mortgaged the property?
our borrowers have mortgaged the property in October 2019, my lord.
October?
So we have, yes, my lord, October 19th, October 2019.
October 2019. He purchased the property when?
3/1/2020.
Oh, having mortgaged the property, you sold it to him.
Yes, madam.
Mortgaged the property to you and sold it to him later.
No, my lord, no. There is, in fact, the builder has actually sold it to them. But the identity of the property is in dispute because they have, the reference to their property is F302, whereas it is only 302 for us. And we have proceeded in accordance with law because the account has turned NPA. And we have issued demand notice to our borrowers and we are in physical possession pursuant to the section 14 order.
What is the address of the petitioner? You stay in that property?
Yes, my lord.
You're staying in the property?
No, my lord, we are in physical possession. It was vacant when we took it, my lord.
So what did he say in this petition?
He's claiming that he's in.
You're arguing or your senior will come?
My senior will come, my lord. Also, I will.
Monday let him.
Monday, yes.
Monday let him come.
I've served him copy. I'll
Serve
file
that
it.
copy.
Yes, ma'am.
Monday.
Great.
Number 20.
My lord, this is the case
Call
where he
KB.
challenged the possession notice and 5 lakhs was paid and they filed one affidavit. But then, my lord, they have sought for 6 months' time without making any commitment in between. So it was they were supposed to
Affidavit is
take
filed with the
instructions.
petitioner stating that they'll pay the amount, but they require 6 months' time. The petitioner shall pay the amount within 4 months in equal installment. As per the order, the petitioners have to pay the amount, but in the affidavit now they are seeking 6 months' time.
I'm ready to
No,
pay.
we can't just like that. We'll not say, wait till 6 months till you have the money. There should be some installment. You can say, like, out of that, if it is 40 lakhs, I'll pay 5 lakhs this month, next month, 5 lakhs. Later, I'll pay, 5, and in the last month, I'll pay this much. There should be some undertaking of that nature. No, you will file an undertaking, 6 months, the bank will wait. And on the 6th month, you will say that I'm not able to pay. And who will answer to this time?
I will pay installment also, my lord, sir.
Then you have to file an affidavit in that regard. The petitioner shall file an undertaking affidavit specifically mentioning how and when he is going to pay the amount. When? March?
March.
We'll have it in March.
Yes, ma'am.
March.
Date.
March
9.
4th.
Great.
Till number 21.
Petitioner.
Raymond,
The petitioner has paid, my lord, all the installment due, my lord. Now account is
Regularized. So nothing.
Correspondent, my lord. Account has been regularized.
When counsel appearing for the petitioner submits that the petition has paid the amount for regularization of the account, and now the account is regularized. What is the question?
Position notice has
Is regularized. When counsel appearing for the respondent back also submits that the account is regularized, hence nothing survives the consideration. As you have dropped the proceedings under the
Yes,
SARFAESI Act.
yes.
Hence nothing survives for consideration.
If there is any further default,
According,
bank.
no, that we don't have to say. If it is further default, you will again start.
Okay, now.
The nothing survives for consideration in this petition accordingly dismissed as instructed.
Hello, this is the position notice.
Dismissed, no, accordingly. Now everything will come to
Everything,
in the light of the
possession-
fact that
possession
the
notice.
account is restructured, the proceedings are dropped. Hence, the notice is set aside and the respondents are always at liberty to initiate further proceedings if the petitioner is
further default.
default in future. Yes.
Obliged.
Next.
Till number 22.
For the petitioner. On the last occasion, my lord, the bank took time to file their reply.
Yes, my lord. The last occasion, learned counsel represented that the encumbered property has been sold by the bank. I was also surprised. Then I collected all the revenue records. It is not encumbered, nothing. I will produce this before this court, my lord.
Then
One day may
counsel
be given,
appearing
my
for
lord.
the respondent bank submits that. Now they have all the records pertaining
yes, my
to this, it is the submission of the land counsel for the petitioner that there is an encumbrance on this property and that property has been mortgaged.
Sold.